to winning isn't easy. The court slams Sedgwick's use of the infamous Dr. Gratton in overturning a wrongful ERISA denial claim. Now, again, according to Sedgwick's website, caring counts. For more than 50 years, we've been committed to doing the right thing, and we do that by living by our core values of empathy, accountability, inclusion, collaboration, and growth. The reality is they do the right thing for them and their shareholders by living their core value of putting profit above what's right for ERISA policyholders or plan beneficiaries. They're not in the business of paying disability benefits. And one of the primary tools that carriers and peer review people like Sedgwick use are the services of an alleged independent physician to review medical records and determine the policyholder or plan beneficiary's restrictions and limitations, notwithstanding what the treating physician might have said. Now, really, if you're interested in doing the right thing, you should be listening to what the treating physician has to say and making a decision not on that, not by hiring liar for hire peer review doctors or liar for hire IME doctors who are giving you a paid opinion to let you deny or terminate benefits. Now, when a denied ERISA disability claim ends up in front of a federal judge, the first thing the judge has to do is determine the standard of review. And there are two standards of review. The first and the more favorable one is called the de novo standard of review. I wish everything was de novo. That means that the court and the judge can substitute their judgment for that of the disability carrier or plan. The second and less favorable one is the arbitrary and capricious standard of review. And the question is not whether the decision is right or wrong. Got that? The question is not whether the decision is right or wrong, but whether the denial is arbitrary and capricious. So one of the ways that the disability carriers or plans argue that the denial was not arbitrary and capricious is the fiction they create for the court by securing a liar for hire medical opinion that create the reason to justify the claim's denial. Now, one of those physicians is Dr. Howard Gratton, and he's commonly used in the ERISA disability word. You can just do Google Scholar and you'll see him. You don't have to take my word for it. But let's talk about the case of Chaco versus AT&T. Chaco was a software engineer who began working for AT&T in 1997, and 20 years later began experiencing severe pain and ache in her eyes, neck, shoulder, and in both arms, as well as blurred vision. Sedgwick Claims Management Services is the servicing agent for AT&T. They paid her short-term disability benefits, and after 3 months of paying long-term disability benefits, they denied her claim on the basis that the medical evidence does not support ongoing disability. And guess who rendered that opinion? The infamous Dr. Howard Gratton. He's got quite a track record, and the court noted that track record in this particular case. In fact, the judge noted that and suggested that Dr. Gratton harbored a bias in favor of the plan, which warranted a moderate level of skepticism about the good Dr. Gratton's medical opinions. Now, his track record suggests that he's more than just biased. The judge noted that Dr. Gratton found that only 8 out of the 61 claimants who had filed disability claims under the AT&T plan were disabled, just 13%. And remember, of course, Sedgwick is all about doing right all the time. Gratton found that 50 of the claimants, 82%, were not disabled. I want you to check out this opinion. Check out Google Scholar. What do you think? You can see that doctors like this are tools for the disability carrier or for the TPA, and they make a really good living giving carriers what they want to create and justify a claims denial or termination. The judge overturned the claims denial, and you can be assured that I added this decision to my laundry list of cases that we cite when we're dealing with an appeal involving the good Dr. Gratton. Remember, Sedgwick said, they can count on us to listen, to respond, to protect, and help make things right. The court, and not Sedgwick, made it right. Let's take a break.
Are you a professional with questions about your individual disability policy? You need the Disability Insurance Claims Survival Guide for Professionals. This book gives you a comprehensive understanding of your disability policy, with tips and to-dos that will assist you in submitting a winning disability application. This is one you don't want to miss. For the next 24 hours, we're giving away free copies of the Disability Insurance Claim Survival Guide for Professionals. Order yours today at disabilityclaimsforprofessionals.com.